The Supreme Court has this morning ruled that the government's plan to send asylum seekers to Rwanda is unlawful. But it's the reasoning behind that that's really important that I'd like to put across in this video, regardless of what your personal views are of these plans or anything else. But as usual, there is a short version and a long version. The long version, I hope you'll stay for and subscribe to the channel for. The short version is the Supreme Court ruled that this was an unlawful plan because Rwanda was not a safe place to send asylum seekers for their application and there to stay there afterwards if their asylum application was successful. Ruling ultimately that this was not a safe country for various reasons meant that the whole plan itself was therefore unlawful. That's the short version, but let's get into the longer version. Now, under this plan, certain people that were going to claim asylum in the UK would have been sent to Rwanda to have their claim decided there by the Rwandan authorities. If the claim was successful, then they would be granted asylum in Rwanda, according to this plan. Under this appeal, there were many aspects the Supreme Court had to look at, but essentially it breaks down into several elements that I will go through in this video. In deciding whether or not this policy was lawful, the Supreme Court had several legal questions to answer, of course, on the basis of evidence and established legal principles, including the law laid down by Parliament. But it also has to be said that the court made clear that it was not concerned with political debate surrounding this policy. And even before talking any further on it, I will make clear that the Supreme Court, in both its press summary and its judgment, has made the very clear statement that is on screen right now, that this court order applies to anybody, that nobody shall publish or reveal the names or addresses of each of these parties, or publish or reveal any information which would be likely to lead to the identification of the claimants or any member of their respective families in connection with these proceedings. So with that out of the way, so just looking at the background of this case for a moment, the legal basis for the Rwanda policy was set out in the immigration rules, made in accordance with Section 3 of the Immigration Act 1971. These paragraphs would have allowed the Home Secretary to treat an asylum claim as inadmissible if a claimant had the opportunity to apply for asylum in a safe third country but didn't do so. They would then be removed from the UK to any safe third country which agrees to accept them. Under these rules, a safe third country is any country which respected the rule of non-refoulement, which essentially means that the country would agree not to send them to any country where their life or freedom would be threatened by account of their race, religion, nationality, or membership of any particular social or political groups. Or, of course, if there would be any real risk of torture and inhumane treatment. So many people might ask the question, why Rwanda? Well, in 2022, the UK and the Rwandan governments entered into an agreement on an MOU, a Memorandum of Understanding, on the basis that arrangements made and assurances given that Rwanda was a safe third country to which these asylum seekers could be removed. Now, in short, a number of asylum seekers to this claim challenge both the lawfulness of the Rwanda policy and the decisions to remove these particular claimants to Rwanda. Initially, the Divisional Court held that the Rwanda policy was in principle lawful. However, the way in which it was implemented in these particular cases was procedurally flawed. The appeal to the Court of Appeal was to challenge only the lawfulness of the policy, and then by majority the Court of Appeal held that this policy was unlawful. The reasoning given by the Court of Appeal is essentially the short version given in this video. That was that the Court of Appeal held that there will be substantial grounds for believing that there were real risks that asylum claims would not be properly determined by the Rwandan authorities, and accordingly that there was a real risk of refoulement, i.e. sending them to an unsafe country. From there, this case made its way to the Supreme Court on two grounds. One, the ground of refoulement, which I've just mentioned, which I'll discuss in more detail in a moment, and the second ground being whether or not this policy was unlawful because it was incompatible with retained EU law. So let's look at ground one first of all. There were three issues with ground one. An issue is essentially something the court has to decide. So the court will hear the background, the facts, the setup, if you like, of the case, work out what the issues are. You may very well hear the term issues if you go to court. The court needs to find out what the issues are and then make a determination on those issues. There were three of them under this ground of refoulement. Non-refoulement, as I mentioned, i.e. not sending an asylum seeker to an unsafe country, is a core principle of international law, which is why you may have heard lots of lawyers saying that this policy was unlawful. And there are several international treaties with which the UK has agreed, including the United Nations 1951 Convention relating to the status of refugees and the 1967 Protocol, collectively referred to as the Refugee Convention, and also ECHR and our own Human Rights Act. Asylum seekers are protected again against being sent back to an unsafe country. The issues in this case to be decided, very simply. Number one, did the original divisional court apply the wrong legal test when considering the risk of refoulement? Whilst the court said that it was unclear from the original divisional court's judgment whether or not it applied the correct legal test, it said that the Court of Appeal would have made that decision for itself. Remembering, of course, that it was the divisional court's decision that was appealed to the Court of Appeal before this found its way to the Supreme Court. The second issue for the Supreme Court, if the divisional court had applied the right test, was it for the Court of Appeal to interfere with that conclusion on the risk of refoulement? The Supreme Court says, yes, the Court of Appeal was entitled to interfere with the divisional court's conclusion because there were errors in the way that the divisional court treated the evidence. And that is because in both European and UK law, it was clear that in cases like these, the court is required to consider how the asylum system operates in the country to which these asylum seekers are going to be sent. But instead, the divisional court held that the Home Secretary was entitled to rely on the assurances given by the Rwandan government instead of making the determination for itself. The third and final issue under ground one was whether or not the Court of Appeal was entitled to conclude that there were substantial grounds for believing that asylum seekers would face the real risk of ill treatment by reason of refoulement following the removal to Rwanda. And in short, the Supreme Court said yes, the Court of Appeal was entitled to conclude that there were substantial grounds for believing that asylum seekers would be at real risk by reason of refoulement if they were removed to Rwanda. The Supreme Court said that it accepts that the Rwandan government entered into an agreement in good faith, that it has incentives to ensure that it's adhered to, and that monitoring arrangements provide a further safeguard. But nevertheless, the evidence shows that there are substantial grounds for believing that there's a real risk that asylum claims will not be determined properly, and that asylum seekers will therefore be at risk of being returned directly or indirectly to their country of origin. The changes and capacity building needed to eliminate that risk may be delivered in the future, but they were not shown to be in place when the lawfulness of the Rwanda policy had to be considered in these proceedings. So in other words, all good intentions, but at the moment the evidence did not support that this was a safe place, that the procedures were in place to ensure that they would not be returned to their own original country or another country that is unsafe. And thus the overall policy has been ruled unlawful. The second ground is a very brief one. That was a cross appeal brought by one of the claimants on the ground that this policy was unlawful because it was incompatible with retained EU law. In short, the Supreme Court said that the relevant articles no longer have effect in UK domestic law as retained EU law because they fall within the scope of the Immigration and Social Security Coordination EU Withdrawal Act of 2020. And accordingly, they ceased to have effect in domestic law of the UK when the transition period came to an end at the end of December 2020. Thus, that ground was dismissed. So allow me, if you will, to just leave you with this. Whatever your personal views about any of this are, the one concluding thought that I would leave you with from this judgment is that it is not right to send anybody to any country that they are not safe, regardless of your political views, your personal views, or anything else. Anyone being sent to any country where there is a risk of torture or inhumane or degrading treatment is simply not something that we as a country should accept. And that, I hope, should be a universal view. But of course, you're entitled to your own views, your own comments in the comment section below. Please do like the video and subscribe. And as always, thank you for watching.